And now please welcome the evening anchor, Q13 Fox Evening News, Mark Wright, who's going to moderate and introduce the rest of our program. Mark.
Thank you, President Bill, fellow Rotarians and guests. The Voter's Guide says Initiative 933 concerns government regulation of private property. The ballot description is pretty short, so I'm going to read it for you today before we have our speakers take the podium. This measure would require compensation when government regulation damages the use or value of private property, would forbid regulations that prohibit existing legal uses of private property, and would provide exceptions and payments. Sounds pretty simple, right? If you're old enough to vote, you know that the devil is in the details when it comes to legislation and law. And if you've been following 933, you know that there's been a pretty heated exchange on a number of questions, like how much will 933 cost local and state governments, and by extension, all of us who pay taxes? Exactly which regulations will it apply to? A lot of unanswered questions remain, and today we're very fortunate to have two very able speakers to help us figure this darn thing out. Speaking in support of 933 is Steve Hammond. Most of you know Steve as a former King County councilman. He is the founding president of Citizens Alliance for Property Rights and is currently serving as their advocate. He's also an ordained minister of more than 31 years and serves as the senior pastor of Cornerstone Bible Church in Enumclaw. And speaking in opposition of 933 today is Doug Walker. Most of you know that Doug is the founding partner and CEO of WRQ, the integration software company. Today, Doug is active with a number of business and community organizations. He's the secretary of the Fred Hutch Board of Trustees and is currently the chairman of the board of REI. Each presenter today will give an opening statement up to 6 minutes long. Larry has the flashcards there, and if you go over, people will begin throwing things at you. Up to 6 minutes. I'm just joking. After that, we're going to have 6 minutes of table talk. I encourage each of you to come up with some questions that your table can then present, because we're going to have an extended period of Q&A today to help us really flesh out the issue of what 933 is. Okay, we determined the order by a toss of the coin on the opening statements. Mr. Hammond, you'll speak first, followed by Mr. Walker.
Thank you very much for this opportunity to be here. I want to thank Seattle Rotary for taking an interest in this issue. I'm asking you to vote yes on I-933 because it's yes to protecting our homes, yes to protecting our farms, and yes to our protecting the way in which we can control our communities and their growth and prosperity. Over the last few years, land use regulations have taken a draconian turn in favor of transferring to government both the wealth and of the private landowner and the ability to use private property as the landowner wishes. Both the choices and the money of the private landowner are being transferred to central planners at an alarming rate. This has resulted to damage to both the use and value of private property without compensation. I-933 is about damage to the use and value of private property. In spite of the fact that planners claim to be doing their work in the public interest, the entire burden and cost for all this regulation falls squarely on the private landowner. Regardless of the use for which the landowner purchased their property, some for retirement investment, others for their children's college education, others to build that first dream home or only dream home, all citizens in Washington have seen their ability to purchase and use land for even the most basic of uses diminished. This is not fair. Yes on I-933, I-933 will help restore fairness to this lopsided situation. To be sure, those who are in charge of central planning and their jurisdictions, which rake in windfall profits they do not have to label as taxes, will not be happy to see individual property rights restored to private landowners. Instead, they are screaming about the anticipated, quote, cost, unquote, to government. Costs they fear only because they know their actions have already reached too far into the realm of the private individual landowner's pocket. Remember, these costs are strictly under their control. They also know about Oregon's experience. After Measure 37, the taxpayers of Oregon have incurred how much? $0, not $1 in cost in Oregon, while the people's rights have been strengthened tremendously. This is beside the scary fact that 90%, over 90% of the claims in Oregon have been deemed valid claims. Yes on I-933 represents an attempt to be fair to those who have had the use or value of their property damaged by land use regulations imposed upon them for the common good. Let's be fair. If a city wanted to put a road through someone's property, they would have to pay for it. If they weren't willing to pay for it, they would have to come up with some other way to achieve the public good that the new road was intended to provide. Yes on I-933 says that all other regulations must follow that same pattern. If they're intended for the public good, they must be treated the same way. Just as government cannot confiscate homes and churches for roads without compensating landowners, neither should they be able to set aside portions of the person's land for any other reason without compensation. This is simply a matter of fairness. If a regulation is for the public good, let the whole public pay, not just the person who's unlucky enough to own the land being regulated. That's what's fair, and by the way, it's in the Constitution. What about those who say that this regulation, this initiative, will cost the government billions of dollars? These so-called costs are really just an admission of how much regulation are already costing the private landowner, and government has been taking a free skate on the cost. Yes on I-933 looks like it will pass now, and local jurisdictions who have been largely silent are now sounding off wildly. Yes on I-933 is fair, and it is a public answer to the regulations passed with arrogant disregard to the effect upon private landowners. But the government doesn't have to pay anything. Remember, it's under their control. I'm out of time. All right. I'm just going to ask you to vote yes on I-933.
All right, thank you, Steve Hammond. Up next, speaking in opposition of 933 is Doug Walker. Doug, you have up to 6 minutes. Thank you.
Thank you, Seattle Rotary. Just tell you a tiny bit about my background. I'm very involved with a lot of businesses since I retired from WRQ. I mentioned Fred Hutch and REI. I'm also on the board of Green Diamond Resource Company, formerly Simpson Timber Company, Technology Alliance board member, Harper Properties, and a couple of technology companies. And I'm also a general partner in a farming and development company called Wilson Farms. Now, my basic reason for opposing I-933, and it's like our slogans, it costs too much and it goes way too far. I'm not in general a big fan of government regulation and planning, but I'm also not ready to see us throw out land planning and the possibility of reasonable regulation, especially with the rate of growth that our state is experiencing, now almost 4 million people in the Puget Sound Trough. By simultaneously allowing unplanned development and taking money away from transportation investment, I see our traffic getting a lot worse. While I certainly would support some regulatory reform, I think I-933 seems to me like the nuclear option. It will be expensive. There's two very reputable studies recently done, one from the University of Washington, the other from the state's Office of Fiscal Management. They suggest a cost of around $8 billion in the first few years. Now, Oregon passed the less drastic measure, and today they're facing claims of $5 billion. These claims may not have been paid, but I'm told that government officials are spending up to 75% of their time just trying to handle the claims that are going against them. I strongly urge you to sit down and read this initiative. It's not that long. It's vague, it's poorly written, and it will lead to years of expensive litigation to sort this out. it actually encourages lawsuits by providing that the public will pay for the, quote, reasonable attorney fees of plaintiffs, whether they win or lose. I think some attorneys may benefit from I-933, though this may be a short-term economy, again, because it will affect our economy. As far-reaching as the initiative is, I was especially frightened in reading this last night. I'll quote from Section 6, quote, "The provisions of this act are to be liberally construed to effectuate the intent, policies, and purpose of this act to protect private property owners." Of course, this is an instruction of the courts to apply the initiative expansively. Conversely, in Section 2 of the initiative, it says the exemptions in this subsection shall be construed narrowly to effectuate the purpose of this act. Now, if you're involved in business and have had legal experience, this probably scares you as much as it scares me. And it's not limited to real property. The language specifically includes personal property. And the implications of the initiative's applications to personal property really aren't fully understood yet, but are certainly scary. You know, I mentioned the organizations that I'm associated with because each of them is negatively affected by this initiative. Those areas are technology, computer and biotech, outdoor recreation, real estate development, timber industry, and farming. As a board member of the Technology Initiative, we work to maintain and strengthen the tech economy in Washington State. Our state is #1 in the nation in per capita postgraduate degrees, but 47th in the production of BAs, right next to Mississippi. We need trained workers to be successful, and we need to have a state that can attract this talent since we're not producing them locally. University of Washington's new Dean of Engineering, Matt O'Donnell, comes from University of Michigan, which is a very fine engineering school. He tells me that 60% of their graduates leave the state. That's good, I guess, for us. But if this happens here, I think we can kiss our tech economy goodbye. All the tech businesses that I work with are very concerned with their ability to attract talent. They don't want something to do that messes up the attractiveness of our state and the quality of life issues that we do well on. You know, it's a matter of public record that the tech leaders in this area are all on the No on 933 campaign because you can look up that they've contributed. Some of these I'll mention are Bill Gates Jr., John Stanton, Nick Hanauer, and Pete Higgins. They've all contributed to the No campaign. REI is the state's largest outdoor recreation company with 8,000 employees and $1.1 billion in sales. It's taken a strong public position against I-933. We believe that I-933 will damage the quality of life and reduce open space and recreation opportunities in our community. By allowing the selective application of zoning laws, I-933 will create uncertainty and instability in our real estate market and affect property values. In fact, this loss of predictability will hurt the overall business environment in Washington. The real estate developers that I work with, Harper Properties, Wright Runstead, Pine Street Development, Vulcan, they see I-933 as very threatening. Not all of them, but some of them have taken public positions against the initiative, but all the principals of these companies have contributed to the No campaign. The timber companies that I work with are worried that I-933 threatens their habitat conservation plans. The timber business has a hard time with environmental regulations in our state and is not a big supporter of regulation. Nevertheless, they view I-933 as too far-reaching. They fear that it will create too much uncertainty in their business. They've worked hard to adjust to regulations and long-term planning, but they'll fear they'll be damaged by I-933. As to farming, let me just do one quote from the Skagitonians to preserve farmland. I'm out. Well, let me just finish by saying all 6 of our living governors have signed on the No campaign, so be sure and go out there and vote No on 933. Thank you.
Okay. Doug Walker, thank you very much. Now we have about 5 or 6 minutes of table talk. I encourage you to come up with specific questions at your table. Then we're going to rove with the wireless mics, and you'll be able to ask these guys questions coming up in about 5 or 6 minutes. I don't know if that was authorized, but I just rang the bell. I have no intentions of running for president. Okay, if I could have your attention, please. Bring your voices down, and we're going to get to the question and answer section of this. Bob, do you want to take the first question there?
We understand that Oregon has passed a similar initiative and that this initiative appears on the ballots in other states. I'd like to know who has originated this idea, And why is it showing up in a number of states, not just Washington State?
I have not read the ballot initiatives in the other states. I cannot speak to that. I think the implication behind the question may be that there's one person that's backing all of this. I can tell you on good authority that is not true. The Farm Bureau got together in this state and pulled together some attorneys both from inside and outside their own organization, but in-state attorneys, and this initiative was written over a period of several months and was put forth by Washingtonians and signed. 317,000 voters in the state of Washington signed a petition saying they wanted to vote on it here. So if I understand the implication, not true that it's an out-of-state thing.
There are 4 ballot issues this year. There's one in Idaho, there's one in California, and there's one in Arizona. There were 2 more that failed to get enough signatures. As I understand it, the primary funding of this comes out of the state of Illinois, but the money comes through a developer from New York. And I think that is the primary source of funding for the Farm Bureau on this. Thanks.
Okay, let's go over to Nancy right now for another question.
The question is, the recent United States Supreme Court decision regarding eminent domain sent a chill through me, and it may have sent a real chill through a lot of other people, and private property rights seem to be under attack across this country. What would you answer to that? Is there any linkage between that effort on the part of the United States Supreme Court and these local initiatives? And what, in any way, assures a private property owner they're going to get fair market value for their property once it's compromised by some kind of rezoning or long-term government planning?
Sounds like a multi-part question. As regards eminent domain, that's been a very, very heated issue since the Supreme Court decision that came out of Connecticut. This initiative, there are initiatives in some states that do relate to that. This initiative mentions eminent domain in its introduction, but has no operational sections that have to do with eminent domain. I believe, I am told, and I'm not an attorney, that in this state we have some independent protections on eminent domain that you do not have in other states. But I think that is a very serious issue that needs remedy.
Thank you for the question. I agree that when private property rights are threatened, all other freedoms are threatened by implication, that they fall when private property rights fall. This initiative could have gone after the Kelo decision or the eminent domain concept, and if eminent domain were being followed correctly, this initiative would not be necessary. However, my opponent is correct. Those who drafted the initiative decided not to go after the eminent domain concept specifically, but rather the regulations that come from that. And I will tell you that my good friend, the Attorney General Rob McKenna, stood up after Kelo and said in this state eminent domain problems can happen, and he was completely embarrassed shortly after that when the Seattle monorail condemned more property than it needed and refused to sell it back to the original owner, and in fact we found out we're not protected from that.
Our table was questioning whether this is a case of 2 extremes, overly powerful regulation on one side and very extreme legislation on the other, and wondered if this bill doesn't pass, or this initiative, what might happen to protect the interest of property owners in some other way.
It is a great concern if this initiative does not pass that it may be open season, even more so on private property owners. In 1996, we tried another measure, Measure 48, which was backed by developers when they were afraid regulation would hurt them. You'll notice this time developers are not backing this initiative, and the reason is they found out they do very well under regulation. In fact, they acquire a lot of private property from individuals who don't have the resources to fight the system, and they get it very cheaply, and then they have the resources to work the system. I'm very concerned about what will happen if this initiative does not pass, and I just want to tell you that those who invest in real estate as an investment, I just want to tell you that if any other investment you invested in were treated the way land use is, we'd be hollering Enron and there would be people going to jail.
Well, when Initiative 933 fails, I think that the state is still left with some very serious issues about property, and they need to be looked at. I have to say that with a complex issue like this, it's very hard to handle an initiative process. Most voters go into the ballot box and haven't really studied an issue like this, and you can't amend it for 2 years. I mean, it's part of why we have representative government, is to to handle complex issues like this. And I think this really needs to be looked at. People I've talked to think there are very serious private property issues that need to be addressed, and I know Cascade Land Conservancy, that worked hard to reach a consensus to work on this issue, has a number of people that are very concerned on this issue, and their intention is to go to work on it. But the idea of throwing out a counter initiative seemed to be crazy, because again, it would probably suffer from the same weaknesses of being so poorly drafted.
Yeah, our table had a question that was related to a question that was asked earlier, which is these seem to be, the initiative seems pretty draconian on one side, and there may be a valid question to address on the other side. Often you find debate in the legislative session, in the legislature. Has this issue gone before the legislature? Has it been debated? If so, what has been the discussion there? And if not, why did the proponents for the initiative first go to the initiative process as opposed to looking for legislation?
You know, it is an issue that has been, I'm not sure why, you'll have to ask Steve why they went to the initiative process. You know, it is an issue that has been considered by the legislature, but I think just the fact that there's been so much debate on this subject will give added impetus to it in the next legislative session.
Thank you. I very much appreciate the question. I believe it is very clearly written. If government takes an action that damages the use or value of your property, they owe you compensation, or they don't take the action. I don't think there's anything ambiguous or unclear about that. 15 years we've gone to the legislature and asked them to take action. 15 years they've stalled us and said no. This initiative's coming out now. The polling says we're up by a long ways. It looks like it's going to pass. And all of a sudden, the governor comes out and says, trust us, if you'll just get past the election, after the election, we'll help you this year. Well, for 15 years, they haven't helped us, and that's why we're now at the initiative process. If the legislature refuses to take action, folks, initiative process is how our founders came up with a way to get around them.
The initiative appears to have a double-edged sword to it, and I'd like both of you to speak to that. And that is, what is the effect of the land value and the use of a neighbor's property when something changes next door? I'd like to have you speak to the personal use and the loss of potential revenue.
Thank you. The initiative very clearly says this, and I've noticed every debate I'm in, the opposition always concedes the point that land use regulation is out of control and something needs to be done. They just always favor the answer they don't have to the one we're offering. What I would like to say to you is there's nothing really ambiguous, or the previous question using the word draconian, there's nothing about it. Listen, here's what the text says. Go to the Secretary of State's website, or yeson933.com. Go to the website and read it. It says, if government takes an action that damages the use or value of your property, they either pay you or they don't do it. It's that simple. So we get into these questions, well, what if something happens and then there's some domino effect? Remember, the initiative does not do away with zoning. The initiative does not do away with evenly applied regulations. The initiative does not do many of the things claimed by the opposition. Although I just think at this point, after this many debates that I've been in, I need to concede the fact that since I-933 qualified for the ballot, Pluto has been declassified as a planet, and it's probably our fault. If government takes an action, they either compensate you or they don't do it. It's that simple.
You know, that is a very serious issue, what happens with a neighbor's land. I mean, and there are certainly issues that have come up about that already in the state of Oregon. One well-publicized one concerns where a farm had a gravel quarry set up right next to it. Certainly your neighbor's actions, unbridled, will affect your property values. Any of you who have been part of a community association are probably familiar with the kind of debates that you have between neighbors. If you cut your trees down, I'll have a better view. If I cut my trees down, I'll reduce the value of my property. It's a very tough issue to sort out, and that's some of the hottest debates are within neighborhoods. I think this initiative helps that along by putting it all in the litigation process, and you know how much fun that is.
Our table doesn't have any attorneys at it, so we were particularly struck by the if you have an action, both sides, or excuse me, the plaintiff has their attorney's fees paid, win or lose. Are we aware of any other legislation or any other situation in which that is true in Washington State?
Basically, this phrase is drafted very carefully and has caused some heartburn to folks who have not picked up the context of what it says. The drafters of the initiative said, what are the two possibilities that Oregon did not foresee that we can protect ourselves from and improve on Measure 37? One was saying, okay, fine, we damaged the value of your property $100,000. You give us $200,000 in fees and we'll give you your $100,000. So they wrote into the initiative that that cannot be done. They cannot charge you for the compensation. The other thing was that we will, with the resources of fighting City Hall, we will absolutely bankrupt you so that you cannot in any way wind up making this practically enforced. And so the way they did that was to simply say that if government wants to fight you about this, they also owe for the attorney's fees. And basically then what happens is they have to stand up and say it's a valid claim or it's not. And if it's not a valid claim, you're out with very little attorney's fees anyway. And these are the things that the attorneys who are already on staff are doing today with the shoe on the other foot. Understand this is already happening today as the private landowner is put in the position of trying to fight uphill.
This is always subject to, quote, reasonable attorney fees, end quote. And I know many of your attorneys, but so what I think you're looking at is a situation here where you, the citizens, get to finance this litigation, and like I said, it should at least short term help some attorneys and create a lot of activity in our courts. So I hope you feel okay about financing that.
Hi. A question about the impact on personal property. You referred to the scope of this initiative as extending beyond land use regulation to regulations that affect personal property. I wonder if you could give some examples of how it might impact it.
You know, that's kind of an unknown area. The initiative itself spells out specifically that they're not just talking about real estate, but they are talking about personal property. There are no examples given, so it's one of those things that's more, would it affect bonds, all kinds of commercial paper and business transactions? I don't know. The attorneys that I've talked to have looked at it are sort of scratching their heads, so I don't have real good answers there for you. It's just, I think, an area where the initiative is weakly drafted.
Scare tactics aside, here's the text of the initiative. Private property includes all real and personal property interests protected by the Fifth Amendment of the United States Constitution or Article 1, Section 16 of the Constitution owned by a non-governmental entity. I mean, even lawyers can't disagree over that.
Okay, with that, I think we've come to an end. Rats, we're out of time. Hey, in all seriousness, though, please give a warm welcome for Steve Hammond and Doug Walker. Thank you very much. And we'll turn it back over to President Bill.
Next week, October 25th, we'll be right back here at the Red Lion. Our featured speaker will be Senator Maria Cantwell, which brings us to this week's pretty good rule. I learned this in the Navy. It's a good one. Stay calm. Lighten up. The first report is almost always wrong. Things are seldom as bad as you imagine and almost always look better in the morning. See you next week. We are adjourned.
Seattle Rotary Online is made possible in part by a grant from First Choice Health, now providing return-to-work services that help get absent employees back to their jobs. Healthy employees produce healthy companies at First Choice Health. And by Enterprise Seattle. For over 35 years, Enterprise Seattle has provided client-based economic development services to businesses throughout King County and its 39 cities. More information on Enterprise Seattle and how they help businesses grow and prosper can be found at www.enterpriseseattle.org.